Something that even I've heard was that in Australia, it is really difficult, or even there needs to be some sort of extraordinary circumstance for you to sue your doctor. Is this a myth?
The answer is that it is possible to sue your surgeon. It's not an insurmountable hurdle that you have to overcome, but what you need to prove is that the actions of the surgeon fell below a reasonable standard of care. And what that means is that what they were doing is not what is expected of a reasonable surgeon in the position that they were in, conducting the procedure that they conducted on you.
This program's content is provided solely for informational purposes and should not be construed as medical, legal, or financial advice. Views expressed are opinions only. Our discussions are general and not focused on specific companies or individuals unless explicitly mentioned. We strongly recommend consulting a qualified medical professional before contemplating any major or minor medical procedures. Be advised that some content discussed may be distressing. Discretion is advised. The hosts of this program believe all people should be able to access cosmetic surgery procedures free from judgment. Welcome to Surgery Secrets, Beauty's Dark Side. I'm Madison Johnstone and I'm co-hosting this podcast with Michael Fraser. This podcast is exploring the dark themes of the cosmetic surgery industry, and today we're looking at the legal aspects of this world. Now, there might be some really important things that you have not considered right at the start of your cosmetic surgery journey that might involve you needing to be prepared should anything turn legal or should you want to pursue a lawsuit at some point. Today we have a medical negligence lawyer, Rosy Listing, who has very kindly agreed to appear on this podcast and talk all things legal with us today. Thank you so much for being here.
Thank you, Madison and Michael. It's a pleasure to be here.
Rosy, you've come all the way from Newcastle today to see us in Queensland. Can you tell us, our listeners and viewers, who are you? What do you do?
Yes, so I'm a medical negligence lawyer. I've worked in the field for about 10 years. And more recently, I've pursued a number of cases against cosmetic surgeons who have failed to meet a standard of care by their patients. I've worked on mass cases involving failed breast augmentation surgeries, and I've seen a lot of pretty confronting cases involving patients who have suffered injuries because of failed cosmetic surgery.
And that's great that you've had a lot of experience in that. We had a guest, Professor Anand Deva here, who's a bit of a breast implant expert, and I'm sure the people that listen to that episode would be interested to hear what you have to say from a litigation point of view as well.
Absolutely. I'm here to talk about what you can do if you think you might have a legal case and how you can go about pursuing that case either in court or trying to get a settlement out of court.
Obviously, when you go in for a consult, your doctor's taking notes or the nurse is taking notes about what's happened, but patients often don't have any of their own notes, so they're relying on that. Is that something, just so that if they do get to that point where they need to be telling a lawyer about what's happened, would you advise that they make sure that they take notes about what has been said to them, how they might have been feeling, those kinds of things?
I would say that that's a really helpful first step. The thing that I would also recommend is that patients do their own research outside of the consultation, and that when they go in to speak with their doctor, they have a list of questions to ask their doctor about areas that they're particularly concerned about. Often these consults are pretty short, and so, with respect to material risks, it's partly the patient that will lead that process and direct the consult in terms of what they are really concerned about. So they should be prepared in that way. That is a helpful first step.
Do you think that of the patients that you have helped along the way, have many patients gone into these consults already very informed? And do they have these kinds of notes that they can rely on?
I don't think I've ever helped someone who's had that kind of process put in place before they've had the surgery done. Most patients, most of my clients have not had the opportunity to go into that level of detail or research the risks before they go in for the procedure.
I was just going to say, you mentioned research. What do you think good research is? Because we've got pretty strong views about the information that's available out there to people and that it's quite biased towards the practitioner. What kind of research do you think would be good to do?
Well, if you have the capacity I would suggest looking at journal articles, which are from peer-reviewed sources, and that really do talk about the risks associated with particular types of procedures that you might be considering. If you don't have that capacity, then I would suggest that you can look at summaries of those types of peer-reviewed research articles, and that's one way forward. The other way is just to start to Google risks associated with particular procedures, because there is helpful content out there, and that can start to form the basis of a conversation with your surgeon to amplify your knowledge of that particular area.
So TikTok, Instagram.
Probably not the best sources. I wouldn't recommend them.
A lot of patients are unfortunately getting their advice from Instagram and TikTok before and after photos. We know that this area is very glamorized. Unfortunately, they might even make people feel insecure about their bodies and give them that little nudge to even want surgery to start with. So how would you, as a lawyer, having seen patients on the other end of this procedure, what would your sort of thoughts be to people who have got their research from Instagram and TikTok?
I would suggest that is a very unreliable source of information, and you've got to be really careful about relying on information that has a particular agenda attached to it. A lot of the time when you're looking at this online information, the people who are posting have a goal in mind, and their goal might not be to keep you safe primarily. It might be to market their own services or, I guess, enhance the impression of themselves online, for instance. So it's the motivation behind the information that is really important to consider. With more objective sources of information, that agenda isn't as prevalent, so it's a more reliable source.
With the regulator says now, like especially under these new rules, that you have to have acceptable evidence in advertising. So, for example, if a breast implant surgery has 1 in 2,000 risk of whatever happening, that if you say that, you have to be able to back it up with evidence, and it can't be anecdotal, such as 5 out of 10 of my patients are the happiest they've ever been. And what we've noticed practitioners doing is they will put what appears to be evidence-based information about the procedures online, and then they'll have like a tiny little star saying, oh, anecdotal, evidence based on my practice. When they go into these consults, and how do we know this particular thing happens? Because they broadcast it on social media, some of their consults or portion of their consult, they run through the risks, and then they end by saying, but, it's a very, if this is done right in safe hands like with us, the risks are very, very low, and you're going to get a great result. So someone who's read those peer reviews and then gone to the doctor, and the doctor said, yes, all those things exist, but then sort of dismissed it all away with, I'm a really safe doctor and you're going to get a great result. What does that patient do?
I think there's potential for conflict around the information that's being conveyed in that situation. So you want a holistic picture of what you're getting into. I think the real issue that we're talking about here is the extent to which risks need to be conveyed and how much detail needs to go into that process. So in Australian law, doctors have to disclose material risks associated with a procedure. If the risk is severe, there has to be disclosure of that severity and the consequences of that severity. Glossing over those risks is downplaying those risks. And so the issue that the court will look at is the impression that's given in terms of the holistic impression around the information that's provided.
So your surgeon, if you have a surgeon and they said you're going to get great results and you're not happy, can you sue under Australian consumer law?
You can sue under Australian consumer law. It does depend on the facts of the case. It's not always an easy way to pursue a case, but generally speaking, there are causes of action that will protect consumers if they have not received the outcome that they were entitled to with respect to a particular procedure. So there are two main kind of causes of action that you could look at under the consumer law. The first is the guarantee of services for a particular purpose, and the second is the misleading and deceptive conduct provision. So with respect to the first provision, what you're looking at is whether what you received was what you were promised by the surgeon. One example of a potential case against the surgeon for failing to provide a service for a particular purpose might be, if you approach the surgeon, you want a particular result and a particular type of outcome in terms of, say, for instance, a breast augmentation. You want a type of profile. You want your breasts to look fuller, for instance, sitting higher up on your chest, for instance. And they say they can provide that outcome with implants. But in reality, that outcome cannot be achieved with the use of implants. And what you really needed was a lift. So if they then provide that service to you, the breast augmentation with implants, and you didn't achieve the outcome that you were hoping to achieve or that you had been guaranteed that you would achieve, then there may be a cause of action under the guarantee that the service is fit for a particular purpose provision. The second action that you might be able to use in the Australian consumer law is the action for false and misleading representations about goods and services. And this used to be called the misleading and deceptive conduct provision in the Trade Practices Act. It's quite a unique provision. It's unique to Australian law, and it doesn't there's no real equivalent in other jurisdictions. And what we see in this provision is that you can pursue a service provider if they made a representation to you which was false or which was misleading, and that you relied upon, and that you then suffered injury as a result. So those different tiers of the process all need to be satisfied. But when you're looking at misrepresentations, you don't only have to show one particular misrepresentation to the court. You can look at the context, the circumstance. You can also look at omissions. So for instance, if you're a patient and you're really concerned about a particular risk and the doctor says that risk will not arise, but you then suffer the consequences of that risk, there may be a claim for false and misleading representation there. I will say at the outset, though, that it's not an easy cause of action to pursue, and the reason is because it's hard to prove that you relied upon the misrepresentation to your detriment. Evidence is it's a high threshold. I mean, there's quite a high evidentiary threshold in these cases, and you do have to meet that standard. You have to prove on the balance of probabilities that that representation was the one that you relied upon to your detriment. So it's not easy to do that. Generally speaking, these types of actions are run under a negligence cause of action, which is just simply that the doctor didn't meet the standard of care expected of that professional, of that profession, or with respect to that particular procedure, and that as a result of them failing to meet that standard of care, you suffered damage.
If I'm a plastic surgeon, and there's quite a few that do this, or people who offer cosmetic procedures in Australia, they say on their website, "You're in safe hands with us. Come to us for the outcome of your dreams." Things like that on their website. Even if in the consult they say to you, "Oh, these are all the risks, blah, blah, blah," and then end it, which you've got no proof of. They say, "Oh, you're going to get a great result." Could you sort of go to the website and say, "Well, look, the website says I'm going to get a great result," or "I'm in the safest hands, but I got harmed"? Could you bring actions under consumer law because of those type of representations?
I don't think you could. But what you could do, and I think this is a helpful approach generally for receipt of particular services, is to ask them to clarify in writing what it is that they're actually guaranteeing to you. Part of the issue that you're raising there is evidence, proof of the case, proof that this representation was made and that you as a patient relied upon it. And so even if your surgeon does make those types of representations, you have to be able to prove that those representations were made. If they're made verbally, it's a little bit more difficult. I will also clarify with respect to those representations, they're quite vague. And they're not promising a particular type of outcome. So it would be quite difficult for the patient to say that they relied upon those specific representations in bringing in action.
What kind of things might be omitted in a consult that could lead you to take this kind of action? Would it be like your doctor failed to tell you that a certain breast implant could cause cancer, or what kind of information are we talking about here?
Actually, that is something that I have considered. So more recently, there's been data that's come out that shows that particular types of breast implants, particular makes and models, have a higher risk of breast implant-associated anaplastic large cell lymphoma, which is a rare cancer. And those particular implants, if they have a higher risk, but the surgeon has not disclosed that risk, and the patient actually develops that type of cancer, but they have a lesser risk and they would have chosen the other implant if they'd been informed about that, then yes, I think there is potential for a case there against the surgeon for failing to provide material information that would have changed the patient's decision.
Is there any other kind of information you can think of off the top of your head that a doctor might omit to sell that service?
I guess it depends on what type of procedure that you're talking about. If we're just focusing on breast augmentation, I think one particularly difficult type of complication is capsular contracture. If you're not informed about the risk of that, I mean, that is quite a common complication, and it happens, and it can be quite severe and significant, and it can require the removal of implants. If you were not told about that particular complication, I think that there is, that's a type of information that should be provided to patients.
I suppose patients don't know what they don't know. So it's kind of hard for them to work out what they should be asking, even if they do try to do research. So I guess what I'm trying to ask is, as a lawyer, what are some things that you might have seen doctors omit or have the potential to omit that have led patients down this road because they were misled or thought they'd get a different result or something like that?
The first thing I would just generally suggest is it's helpful to go into that consult saying to the doctor, I am a concerned patient. I want as much information as you can provide to me. I want comprehensive, detailed knowledge of the risks. Start from that platform. The next thing I would suggest is what I've found in some of these cases is that the patient has a particular anatomy, okay, or everyone does, but the type of procedure that they want might not be suited to them. For instance, they might want a particular size of implant, but that's just not going to fit with their body, their frame. The placement of the implant is just not going to work. I think that one thing that is worth considering and taking into account is, at least one thing that's worth asking the surgeon is, can you advise me in detail on the most appropriate type of procedure for my body and taking into account my unique anatomy and my structure? A lot of the cases that I've dealt with involve misplacement of implants or, as I mentioned earlier, procedures which do not suit that body. They do not fit the frame. They aren't appropriate for the outcome that patient wanted. So I would suggest that the risks are, they need to be comprehensive but also tailored to that particular patient. And so those two platforms for disclosure should be put out there, asked of the doctor. And starting from that perspective is really helpful first step as well.
A thing that we've heard about anecdotally, but on many occasions in the industry, is people going to see a surgeon and the surgeon, and we hear this through sort of people from the industry, makes notes in the patient's file that don't reflect what happened. So could be in anticipation of litigation, they write patient had unrealistic expectations, even though the patient didn't, just to cover them if they need to whip it out later. Or patient was told all of these things, or patient came in after surgery, told everyone they were so happy. When the patient actually came in to make a complaint, like, I'm having pain, I'm having complication, what do I do? How do they defend themselves against this? So if you were to bring litigation, what do you do in a scenario where these fake notes are being made in the system to protect the practitioner?
Okay, there's a number of steps that you can take. The first is you can ask the surgeon if they're okay with you taking notes in the procedure, or at least in the consultation. And they should agree to that, because if they've got nothing to hide, if they're a comprehensive and helpful surgeon, then why would they not allow you to do that? You can ask to take a video. They have to agree to it. You can't use it without their consent, but it's something that you can ask. I have consulted clients who have asked for videos to be taken of their explant surgery. Doctors do that. And some doctors, provide that footage to the patient after something has gone wrong, because, in terms of after something may have gone wrong with a different surgeon, because that becomes evidence for a case that they might want to pursue against that different surgeon. The other thing that you can do is request a copy of your clinical notes. You can review them. Every patient has a right to request those clinical notes. In New South Wales, it's the Health Records Information and Privacy Act, and you have a right to see your medical information. You do have to pay a small fee for the production of that information, but they do generally provide it quite quickly. And if you review the notes and you find that there's something in there that you didn't consent to or that wasn't discussed with you, you can actually just email the surgery and say, this is incorrect. I want this record addressed, because that was not appropriate, and that was not something that was discussed with me at the time. Being proactive around those types of actions can be really helpful to reset the record. At the end of the day, another thing that can be really helpful is to bring someone with you, so you're not the only person who has that particular version of events. And you can ask the doctor's consent, to have someone, support person in the waiting room with you, because that can really help to ensure that there's not only one side of events, one version of events that's being put forward.
I love that advice. That is, I think, going to be really insightful for people. Even just the knowledge that they can request those clinical notes. I think a lot of people don't realise that. So thank you for providing that.
Can you sue your doctor or nurse for botched injectables or thread lifts?
Generally, the answer is yes, you can. Of course, it depends on the type of complications that you may have suffered and what actually went on in the procedure. In all of these cases, what we are looking at is whether the doctor conducted adequate pre-operative activity, so looked at your anatomy, made sure that this was an appropriate procedure for you, whether the procedure was conducted appropriately in terms of the actual procedure itself, and then whether they conducted the post-operative actions appropriately.
So one of the things that we know about is a vascular occlusion, where essentially the blood flow gets blocked and can cause your skin to die, becoming like necrotic, they call it, so dead skin. And we hear that these things are more common than maybe the public realise, because practitioners don't like to announce their complications. So those kinds of things, you can sue for those?
Yes, I think you can, and it would, again, depend on the facts of the case. But as you mentioned, a vascular occlusion is like a blockage in a vessel, and a vascular occlusion might result from misplacement of filler, for instance. So if you suffered this complication and your doctor didn't take important precautions during, or post-operatively, then you may well have a case against them. So in terms of before the procedure, these particular procedures are risky. Even though they seem like less invasive than other types of procedures, they still carry significant risks. So particularly with filler, I think that a lot of people might not realise is that you can have significant complications from these types of procedures, even though they're not involved surgical procedures. filler requires a really detailed knowledge of anatomy and variations of anatomy. And the placement of the filler that's a very sensitive area. If your doctor has not analysed your anatomy appropriately, if there's previous scarring that they've overlooked, if they've placed it in the wrong area, and then you have suffered a vascular occlusion because of that, then there is a potential for a case in medical negligence. As well, after the procedure, if appropriate precautions were not taken to mitigate the severity of that vascular occlusion, for instance, massaging, applying heat, and recognizing that complication is something that is arising, then you may have a case against the surgeon for failing to reduce the severity of that complication.
Botched thread lifts. So you go to a cosmetic practitioner, nurse, whatever, and they give you thread lifts and it goes really bad. Can you sue for that?
I have seen cases of where the thread has not been placed appropriately, or that it's extruded from the skin, and that's resulted in an infection. And that is not supposed to happen with thread lifts. And if that is a complication that you have suffered from, then there is an arguable case of negligence there. The argument is that if the thread had been appropriately placed so that the wound had sealed properly, then the infection wouldn't have arisen, because it can't arise where the wound is healing properly. So under those circumstances, you may well have a case.
What are some common reasons that you've experienced as a lawyer for patients suing their doctor in the cosmetic surgery area?
Broadly speaking, the main reason is that patients did not get what they were expecting. Specifically, what I have seen is a promise that was not fulfilled by the doctor, in the sense that the doctor has promised a particular outcome or even guaranteed that particular outcome to the patient, and it wasn't achieved. And it wasn't achieved because it couldn't have been achieved with that particular type of procedure. Ongoing complications that do not resolve. And one of the main complications is just ongoing pain. So I have seen a lot of cases of nerve damage which just doesn't resolve. And that is a complication which really shouldn't be arising. And if it does arise, then it's hard to, it's very difficult for it to resolve. And so it really impacts patients' quality of life. It can result from medical negligence if the placement of the implant, for instance, was incorrect. A lot of the cases that I've worked on also involve psychological trauma that's been suffered by patients. Things that went on in the procedure which they did not want to see, they did not want to be a part of, but they've been exposed to. Some patients have been woken up in the procedure. Some patients have not been given adequate anaesthetic, for instance. And those types of experiences can result in significant psychological trauma. And so I've assisted patients who have suffered those types of complications as well.
Something that even I've heard and had the belief was that in Australia, it is really difficult, or even there needs to be some sort of extraordinary circumstance for you to sue your doctor, that there is some very difficult threshold that needs to have been met for you to successfully bring a medical negligence lawsuit. I believed that. I've heard that, but I've since heard that maybe that's not the case, and there could be any number of reasons for you as a patient to sue your doctor. And I think maybe a lot of cosmetic surgery patients think, well, I've just got some nerve pain, or I'm not mentally right now, but I don't meet that threshold to be able to sue my doctor for medical negligence. Is this a myth?
The answer is that it is possible to sue your surgeon. It's not an insurmountable hurdle that you have to overcome. But what you need to prove is that the actions of the surgeon fell below a reasonable standard of care. And what that means is that what they were doing is not what is expected of a reasonable surgeon in the position that they were in, conducting the procedure that they conducted on you. In order to prove that, you do need an independent opinion from a medical expert. More and more medical professionals are coming forward, and they're they're prepared to speak out and say, look, this just wasn't appropriate. This wasn't what was expected. And so it is not too difficult to find a practitioner who is willing to put forward their opinion and support you in your case these days.
So do you think it's worthwhile that if a patient, cosmetic surgery patient, feels like maybe they have been harmed and maybe they've held this belief that it's too difficult to even bring a case, would your advice be to just go to a lawyer anyway, just to see what their rights are?
Absolutely. That would be my advice. If you have a suspicion that something has gone wrong, start with that and just go and talk to someone. Go and talk to a lawyer. Most lawyers who work in this field will be willing to speak to you for free. They'll consult you. They'll tell you what your rights are. It doesn't cost you anything. It at least gives you a base point to understand whether you do or you may have a case. It's certainly worth taking that first step.
Because I think what we heard was that basically your quality of life had to have been diminished to an extreme amount for you to bring any kind of action. And that's sort of where this is stemming from, is I think that there's this belief that going through the legal process is very difficult, long, emotional, and you're going up against somebody who's probably very wealthy, they have insurance, and actually your chances are not even that great because in Australia it's very hard to bring these actions. So it's interesting that maybe you're not the first lawyer to have sort of dispelled that myth a little bit. So it's interesting, and I think it's important for patients to know that if they do feel like they've been harmed, that hope isn't lost.
What are some roadblocks when you want to sue your doctor?
I think one of the major roadblocks is an evidentiary roadblock, proving your case. Often you can overcome that roadblock by looking at what happened after the procedure was conducted. So if you have complications, an expert will be able to see those complications just from the way you present right now. So even if the evidence isn't contained in the clinical notes of the surgeon, an independent expert will be able to evaluate the complications that you're presenting with and help you overcome that particular hurdle. Other roadblocks, I think one significant roadblock is fear. Fear and shame of bringing a case. In terms of overcoming that roadblock, you need to have a supportive lawyer who can help navigate the system with you, support you through that process. There is, of course, like a financial roadblock that is an important consideration in cases. If you do have a good case, the lawyer will generally fund it on a no-win, no-fee basis. They might engage a disbursement funder, which will help you fund the expert reports that you need in order to prove the case. And then that comes out of the settlement at the end.
Have you encountered any patients who have signed NDAs and have not been able to bring action against their doctor?
Yes.
So a non-disclosure agreement?
Yes. I have assisted a number of patients who complained about their surgeons and were essentially paid off. They were given a refund in exchange for withdrawing their complaint and not pursuing the case. After that NDA was signed, they have come to, a law firm and they've still been able to pursue that case, notwithstanding the NDA being signed, for a number of reasons. One is that they were not given adequate advice on what the effect of that non-disclosure agreement meant, so it's arguable that it's ineffective. The second thing is that oftentimes it's up to the defendant or the surgeon to produce a copy of that non-disclosure agreement so that they can rely on it in barring that plaintiff from bringing in action. And they have in the past, on occasions, not been able to produce a copy of that non-disclosure agreement.
That's super interesting. So even if you've signed an NDA, there could still be hope that you could bring an action if you feel that you need to do that.
Yes, absolutely. And, you can seek advice on the content of that NDA. And when you are signing an NDA, you should be really given advice on the effect of that NDA, what it means, what you're barred from doing. Every NDA is different, so you may be agreeing to certain things but not others. It really depends on the scope of that NDA and what you're barred from doing as a result of that.
So we've gone through a lot of different laws that patients could sue under, what kind of things they might sue for. How do you sue your surgeon? What are the steps involved?
I think the first step is just to approach a lawyer and just explain to them your case. What is your case? What happened to you? What are the complications that arose? And why do you think that that was not as would be expected? Whenever I assist a client, that's the first step. I have a detailed consultation with them and I ask them what happened. So after that step has taken place and the lawyer has heard the, events, the version of events that you've provided, they will then give you advice as to whether they think there is a case there, and they'll start the investigation process. The investigation process involves seeking copies of your clinical notes from the surgeon and also any other evidence that might be available. One piece of evidence that's often used is photographs of, the complications that you might have suffered, and also any clinical notes from surgeons that have treated you subsequently. So if you had rectification surgery done or revision surgery, then clinical notes from that surgery will be requested. Then the next step is to provide this information to an independent medical expert who can provide an opinion on whether the standard of care was met in this case. And once you have that opinion, then you can move forward and file the case in court. Generally speaking, in these types of cases, you will need to pursue a case through the court system. It's rare that you can achieve a settlement outside of court. It does happen, but it's not as common. Generally speaking, the case will require you to file what's called a statement of claim in court, which is essentially a document which just outlines the details of your case, how it occurred, and the types of damages that you have suffered. Once the case goes to court, it gets put into a case management process. And generally speaking, that case management process aims to have your case go to trial a little bit after 9 months from the date that you filed the statement of claim. And in between that time, both parties are entitled to get more evidence. The other types of evidence that you might want to obtain are basically evidence that shows the losses that you have suffered, and that will help you to prove your case, prove the damages that you're seeking to recover, and help you show the quantification of the loss that you have suffered so that you can use that to negotiate a resolution of your case or a settlement sum from the doctor's insurer.
It sounds like a process that you might need to be mentally prepared for, that it's not going to be instant, and it could take a little while to get a resolution, if you get a resolution at all. How long after you have had the procedure that botched you or didn't give you the results that you wanted, how long after that do you have to make a claim?
Okay, so what you're talking about there is limitation periods. There are different limitation periods depending on the jurisdiction that you're in. If you're in New South Wales, the limitation period is the date of discoverability. So it is 3 years from the date that you become aware that you have a cause of action against this defendant. What that means is that you generally need to have received a medical opinion which says, yes, this was a failed medical procedure, it didn't meet the standard of care, and you have a case there. And you also generally have to have received legal advice that you will have a case. In other jurisdictions in Australia, it's 3 years from the date that you suffered the injury. So overall, we tend to advise clients that you're looking at that time frame of 3 years from the date of the injury, and that's just to be careful. You want to really approach a lawyer as soon as you can after the injury has occurred so that you're not running foul of those limitation periods.
How long are these cases likely to run for on average? And I know I'm speaking very generally here.
So if you have a really proactive lawyer, you might resolve your case within 12 to 18 months, sometimes even earlier. If your case is really straightforward, if it's a clear case of negligence, it can be easier to get the case resolved. Sometimes insurance companies just want to resolve the case and they know that they really can't defend it. So in those circumstances, you might be able to resolve your case within 6 to 9 months. If you have a more complicated case where it's a little bit more difficult to prove and you might need to file your case in court and really prove your case, you're looking at around maybe 4 to 6 months to develop that case, to bring it up to a position where you can really file that case in court, and then another 9 months to prepare evidence, and then you might be able to resolve it by negotiations or by mediation within perhaps 4 months or 5 months after that. It does depend on the complexity of the case. A more complex case will take a little bit longer.
I know a payout isn't always important, but it's an element of bringing litigation against a practitioner who harmed you or didn't give you the outcome that you paid for. So what kind of money could you expect to get as a result?
You're entitled to recover loss under different categories. So you can recover damages for pain and suffering, loss of enjoyment of life. You can recover for the amount that you spent on past treatment, the amount that you're going to spend on future treatment to rectify the damage that you've suffered. You're entitled to recover economic loss, which might be lost wages for undergoing the procedure or suffering the complications from the procedure. You're also entitled to recover future economic loss, so wages that you have to forego because you need to recover. You're also entitled to recover the amounts of money for care and assistance that you have received because you couldn't do certain things. For instance, you might have been restricted from driving so that you can recover, or you might need help with caring for your family. So you can recover a sum of money per hour for the time that other people have spent helping you get by day to day. Overall, I've seen cases that have ranged from, $120,000 all the way up to $300,000, $400,000 just for botched cosmetic surgery procedure. The main head of loss is around pain and suffering, loss of enjoyment of life. That's always the biggest, that's generally speaking the biggest head of loss that you are looking at for these types of cases, and it can be significant. It can be in the hundreds of thousands of dollars.
Is it important for prospective plaintiffs to know that there's a chance they could get nothing as well?
Yes. It is important to know that there is always a risk that they aren't successful. In this industry, the lawyers that are working in this field generally act no win, no fee. So what that means is that they take the risk as well when they take your case on. It's not in their interests for you to not recover damages because they don't get paid either. If a lawyer is advising you that it's worth pursuing, then there's less of a risk that you won't receive nothing. Unfortunately, in our litigation system, in order to receive damages, you have to prove liability. You have to prove fault on the part of the doctor. And that is, on the balance of probabilities, more probable than not that the doctor didn't do what they should have done, and as a result, you suffered damage. You do have to clear that threshold. If you don't clear that threshold, then yes, you will not be successful in your case.
Is it true that if the practitioner has poor record keeping of what took place, that it's in your favour?
I think it cuts both ways. I think that it can be unhelpful to a case because there's limited evidence to show what was discussed. Sometimes clinical notes can help prove a case if they show an omission, for instance, if they show that something wasn't discussed where it should have been discussed. It can be helpful as well in the sense that it might not hurt your case because there's no evidence in the converse position. There's no evidence to show that something wasn't discussed, for instance. But I wouldn't say either way necessarily that it either, overall it hurts or helps your case. It's I can't be definitive about that, generally speaking.
What are some roadblocks as a lawyer to representing a patient against a doctor when you're bringing a case?
I would say there's two main roadblocks. The first is confidence on the part of the plaintiff. A lot of plaintiffs need support. They need a guide. They need to know that it's worthwhile pursuing the case. So assisting them to gain the confidence to progress the case is a big part of the plaintiff lawyer's job. The other roadblock that a lawyer will face is evidentiary hurdles. So getting enough evidence to prove that there was a significant failing here, or the doctor didn't do what they should have done. We've talked earlier about surgeons coming forward and being more prepared to assist in these types of cases. So that hurdle is becoming less challenging because your case is really very heavily dependent on the opinions of independent experts.
Should patients prepare for a lawsuit from their very first consult with a doctor?
I think it can be problematic to go into a procedure anticipating that this is going to result in a lawsuit. I think a better approach is to approach it from the position of empowerment and a collaborative experience with the surgeon and a very deeply informed position, so that you are looking at the surgeon as both a guide but also a trusted professional and someone that will do the best by you, and that you can be heavily involved in that happening, in that outcome being achieved.
Are patients often afraid to sue their doctor, and if so, why?
Yeah, patients can often be afraid to sue their doctor. Often they're scared of the authority. They don't want to question that the outcome that they received was inadequate or not as they had hoped or not what should have been received. There is a high degree of respect and trust for the medical profession. So often when something goes wrong, people may not believe that it was because of the negligence of the surgeon, for instance. Realizing that, doctors are people and sometimes things can go wrong and sometimes mistakes do happen can be the first step for them to take this type of action.
Have you noticed a difference between cosmetic surgery patients and any shame or fear they experience compared to patients of other medical procedures?
I have noticed. And what I've noticed is that there's a common theme that often arises in these types of cases, and it relates to fear and shame. That can make these cases a little bit more complicated from the legal perspective because patients are so hesitant to pursue the case because of this shame associated with what happened to them.
There's a lawyer on every corner. What kind of lawyer should somebody consider choosing when looking at suing their doctor?
Well, the first thing I would say is experience. How long have they worked in the field and what kinds of cases have they worked on? And the second thing I'd say is, how comfortable do you feel with a lawyer? Do you feel like you trust them? Do you feel that they are someone that will really stand up for you and pursue your case with passion and energy? Because that is important to driving it forward and to ensuring that you get a positive outcome. The other thing I would suggest is just get a gauge on how proactive they are. You can do that from the very first consult. As soon as you meet them, you can you'll get an impression of how they work, how they respond to your queries, how they address any particular types of complex questions that you may have, and that will give you an impression as to whether you feel comfortable with that particular lawyer.
Should a patient have a red flag with a lawyer if they've been guaranteed an outcome?
Absolutely, they should. And it's very difficult to guarantee an outcome in any type of medical negligence case. The way these cases develop and evolve does mean that sometimes unexpected events can arise, which mean that your case may not be able to be pursued. So anyone who's guaranteeing an outcome is being unrealistic in terms of how the case will evolve, generally speaking. That would cause me to be quite wary.
For those out there who are considering taking legal action, but all they really want, they just want their money back or they just want revision surgery, is legal action the way to do that, or is there maybe a more effective way?
Look, I understand that the legal process is complicated and it can be a less desirable path to take. One way that you can start to address your issues is by just seeking a response from the surgeon, asking whether they'd be willing to address the issues and seeing if they will offer the refund for the particular issues that you have. I would suggest that there is a risk there that if you do go down that path, they might ask you to sign a non-disclosure agreement. You might sign away some of your rights. So it's probably not the preferable path. The other thing is that I think that the impression of the legal process is that it is convoluted, it's complicated, it will take forever. It's not, you're not going to get the outcome that you want at the end of the day. But in my experience, these cosmetic surgery cases don't take as long as a standard, more complex medical negligence case. You can resolve your case quite efficiently, and you will, oftentimes the clients that I have represented end up with more money than what they hoped for and a better outcome, and they can then go on with their lives. So whilst, you might think that you're saving time and stress by, trying to avoid the litigation path, it may not be as challenging as you think it is from the outside.
Are there any interesting cases that you have encountered that you think might be important for prospective patients to at least consider or know about?
Yeah, so what I'm seeing in my practice is an increase in failed labiaplasties, failed vaginoplasties, or vaginal rejuvenation surgeries. And this is a really sensitive area. I believe it's a really problematic area because we have a sensitive anatomy, an area which is very complex and it's unique to each individual. And I believe that there's also a lack of training, a lack of education on the part of certain practitioners that are conducting these procedures. There are women out there who have provided information which suggests that the training is just inadequate in terms of these types of procedures. And so what results from that is potential for permanent disfigurement, permanent nerve damage, and also functional restrictions. So for instance, if you have suffered from a failed labiaplasty, you may not be able to orgasm ever again. You may not have sexual function ever again. And then there's shame associated with that. And there is also the social stigma attached to it. And it can affect people's lives permanently. I think there's a really important conversation to be had around failed labiaplasties, failed vaginal rejuvenation surgeries, because this is an area that's being heavily promoted in the cosmetic surgery industry. And what we're seeing is the portrayal of anatomy, which is just normal, but it's being held up as abnormal, as something that needs to be fixed, as something that people should be ashamed of. Women are seeing these pictures, they're seeing a commentary on, normal anatomy and thinking that what, they have is abnormal and that they need to get it fixed. I think it's, we're just scratching the surface of this issue. It's something that is growing, becoming more of a problem, and really needs to be addressed more and brought out into the public discussion.
Thank you for sharing that. What we are aiming to do with this podcast is to honestly, it's to balance all of this marketing out there that is making really everyone of all ages, of all backgrounds, making them feel like they're not normal, like perfectly normal variations in their body need to be fixed and fast, because obviously they're not confident, they're not living their best selves. They would be way more empowered if they came in and fixed all these things that are wrong with them. And one of the big aims of this podcast is to balance that with actually there are things that can go wrong. Actually, there's probably nothing medically wrong with you at all. You probably are perfectly normal and you shouldn't be shamed or being given these insecurities into thinking that there's something wrong with you. So that's sort of, we really want to start these discussions more deeply and even hold a mirror up to the industry and reflect themselves back onto them to show them that this is what you're doing. Is this what you set out to do? Because it is what you're doing. So it's really, I think it's really important to hear your perspective as a lawyer, some of the things that you've been seeing. So I'm really grateful for you sharing that.
I want to talk to you quickly about medical devices. And in Australia, we have some practitioners using something called an internal bra, which is, I believe, in some cases a mesh that they put inside when they're doing breast implants. Now, when I hear the term mesh, I think of the case to do with the vaginal mesh that didn't go so well for those patients. Do you know anything about these mesh internal bras? And are they risky? And what do you think could happen down the future?
Yeah, so the internal bra reference, it means a variety of different surgical techniques, one of which is sutures to reinforce the implants, and another is the mesh that sort of acts as a scaffolding or a structure to support the implants. And it's a permanent implant. It's something that must sort of stay in the body permanently and cannot be removed. As far as I understand it, the intention of that medical device is to remain in situ permanently. This is a medical device, just the same as any other implant. It has to go through the standard approval procedures that are required of any medical device. And in Australia, there's various pathways that can be taken. So the device can be approved by a notified body, which is sort of like an auditing body that conducts a review of the medical evidence. That happens overseas potentially, or it can be the review can be done by the Therapeutic Goods Administration in Australia. So every medical device that is approved for sale in Australia needs to be registered on the Australian Register of Therapeutic Goods. There are a variety of different internal bra styles, and often they are made of like polypropylene mesh. So there are risks associated with those devices, just like any other implant. Generally speaking, any medical device that's been approved for sale needs to have adequate evidence to suggest that it is safe for use. And so there should be clinical data associated with it that was provided to support the device, to support the fact that it's included in the market, that's being provided to consumers. But manufacturers also have to provide information to doctors about the risks associated with that device. And they tend to provide that in warning sheets and instructions for use. So if you are thinking about undergoing this type of procedure, which is a very involved procedure and it will involve additional risks because of this implant, you should ask your doctor for a copy of those warnings and advices, because that should have a comprehensive list of the risks associated with that device contained in that document. With medical devices, there is actually a higher threshold for risk disclosure as compared to medical negligence. The threshold is that the manufacturer has to warn about all risks, which means the severity of the risks as well as the frequency of those risks. And so generally speaking, the manufacturers should be providing really comprehensive information about all the risks associated with that device. The other way that you can sort of empower yourself with that type of medical device is to look on the Australian Register of Therapeutic Goods, look for the model number of the device that you're about to consent to. You can also look in what's called the database of adverse events. And each jurisdiction has a list of, adverse events that are associated with the device that consumers report or doctors report, and those can be accessed publicly. So any consumer can go on there and, type in the make and model of the device and find out what people have complained about. Now, it's not always comprehensive because patients aren't always reporting the risks that, arise from this device, but it is a good start to understanding what you're getting yourself into when you consent to receiving this type of device in your body.
We have the situation where they're using implants, which we heard from our other guest, Professor Anand Deva, that the data is starting to show over time that bodies do have a response to these devices, and that some women do get associated illnesses as a result of having implants in. So now we're seeing the introduction of a mesh being put in with the implant. So you've got two devices on either side of your body working together. I know you're not a surgeon, but that could increase the risk to you, right?
I think that anytime you're consenting to a medical device, you are taking on a number of risks, and the risks might be unique to that medical device. If you're consenting to two medical devices at once, you are receiving two separate sets of risks, and you also are receiving risks that might arise through the way those two devices interact with one another. And absolutely, I think it increases the chance of complications, just statistically speaking, because of those separate sets of risks that you're consenting to together.
So we're on our final segment now. We ask all our guests these same questions. What to you is the dark side of the cosmetic surgery industry?
For me, the dark side of the cosmetic surgery industry is shame. It's the shame that drives the patients to want procedures that they don't need, that are unnecessary, that don't improve their quality of life. And then it's the shame that they suffer when the procedures go wrong. And some of my clients have not left the house in years because of what has happened to them following a failed cosmetic surgery procedure. It can be incredibly debilitating. It can cause you complete social isolation. And I think often the shame associated with this industry or the complications that can arise from this industry can be more debilitating than the physical restrictions or the physical injuries that you suffer if something does go wrong. One of the things that we hope as plaintiff lawyers in this field is that we can reduce that shame. We can help people become empowered and make sense of what's happened to them in a different frame of reference, in a different light, so that they can realize that it wasn't them that was the problem, and they can move forward with their life knowing that after having their case resolved.
Rosy, what are 3 tips that you would give to patients?
Okay, so the 3 tips I would provide are, first of all, take charge of informed consent. Take charge of your consultation with the doctor and empower yourself with knowledge. Go in there with questions. Don't stop until your questions are answered. The second point I would suggest is, if you think you might have a case, approach a lawyer. Don't be concerned that, your case may amount to nothing. The lawyer will take your case seriously. They will investigate it for you. The third point I have is, don't be ashamed. Don't let fear stop you finding out what happened or moving forward with your case or investigating what happened to you.
And what are 3 tips you would give to practitioners?
Okay, so the 3 tips I would provide to practitioners are, first of all, informed consent. Meet the patient where they stand. Take the time to fully consult them, provide them with detailed knowledge of the risks associated with the procedures. Secondly, patience over profits. And third, if you are not skilled in this area, don't go in and conduct that procedure.
Some people say patients who get surgery are vain and they deserve it if they get botched. What do you say to those people?
So I would say to them that it's unhelpful to be dogmatic or too moralistic about this. The reality is that cosmetic surgery is here. It's with us. It's something that people are going to go and pursue. It's part of our culture. And in some ways, it's a natural reaction to what is a very human desire to postpone death, to prolong life. So it's here to stay. But when you're looking at the actual procedure and the rights and obligations that attach to it in terms of protection to the patient, these are serious procedures and they involve high standards of care. And the reasons for the procedure have nothing to do with the standards of care that need to be applied to the way that procedure is conducted.
Today we've been talking about legal options for patients, and if there's one takeaway you should have from this podcast discussion is that no matter what, if you feel like you've been harmed, it's best to just at least understand your legal options and if you have a case to pursue. Make sure you follow us on Instagram and TikTok at operation.redress. Thank you so much, Rosie, for your time today. I think that there's been incredible value for our listeners who are wishing to undertake cosmetic surgery.
Thank you for having me.